Good evening, everyone. My name is Mia Bassett and I'm a personal injury lawyer advocating for patients and medical consumers. Today I will examine whether the law relating to medical liability failure to warn in Queensland adequately balances the needs of medical consumers and patients, injured people and society in general. First, I will outline the current state of medical negligence law in Queensland as it relates to failure to warn. Second, I will critique the effectiveness of this framework in practice. And finally, I will propose reforms, including consideration of a no-fault compensation scheme to better compensate victims. Failure to warn is a specific kind of medical negligence. Section 21 of the Civil Liability Act, Queensland 2003, the CLA, states the proactive and reactive duty of doctors to warn patients of risk. Failure to warn legislation outlines the duty of doctors to disclose any information that a reasonable person in the patient's position would require to enable them to make a reasonably informed decision about whether to undergo medical treatment. The doctor must disclose any material risk that the doctor knows or ought reasonably to know the patient wants to be given before making the decision. Medical negligence in Queensland costs Australians more than $390 million in total between 2018 and 2023. The Mabel study, a large cohort study of Australian doctors, found that 885 out of 15,000 surveyed doctors reported being named in a medical negligence claim between 2011 and 2018. Patient safety experts from the University of New South Wales Law and Justice Department know that up to 18,000 Australians die each year from medical error, and more than 50,000 suffer permanent injury. According to the Australian Institute of Health and Welfare, approximately half of all negligence claims are discontinued or withdrawn, with only 2 to 3% going to judgment. These figures emphasise a large gap between incidents of medical negligence and the comparatively few successful claims. The current law in Queensland governing medical liability for failure to warn does not adequately balance the interests of patients, injured individuals and society, given the high prevalence of medical negligence incidents compared to the small number of successful claims. Therefore, the framework for proving failure to warn cases requires critical analysis and significant reform to improve fairness and patient protection. The current process for bringing a failure to warn claim in Australia requires the plaintiff to establish 1. A duty of care was owed by the medical practitioner, 2. A breach of that duty by failing to disclose a material risk occurred, 3. Causation linking the failure to the harm suffered, and 4. That no relevant statutory or common law defence applies. This framework is governed by both case law and legislation such as the CLA. The duty of care between medical practitioners, MPs, and patients is defined in common law in Rogers and Whittaker. A duty to exercise reasonable care and skill in the provision of advice and treatment is imposed on the MP. This duty can be characterised as a single, comprehensive duty covering all the ways in which a doctor is called upon to exercise his skill and judgment. This duty of care applies to all registered medical practitioners, arising as soon as the practitioner-patient relationship is formed. Confirming the common law established in Rogers and Whittaker, Section 21 of the CLA elaborates, doctors have both the proactive and reactive duty to warn patients of material risks. They must disclose information that a reasonable person in the patient's position would need to make an informed decision, as well as any information that the doctor knows or should know that the patient would want before deciding on treatment. While the duty of care between doctors and patients is well established, in practice it can only really be enforced through litigation. As Whisper and Breen 2012 observe, this creates a significant gap between the existence of legal rights and their effectiveness for ordinary medical consumers. A breach of duty in failure to warn cases arises where a medical practitioner fails to disclose a material risk to the patient. In Rogers and Whittaker, the High Court held that disclosure is to be assessed by reference to the patient, not by professional opinion. A risk is material if, in the circumstances, a reasonable person in the patient's position would be likely to attach significance to it, or if the practitioner knows that the particular patient would likely regard it as significant. This test incorporates both an objective element and a subjective element. Section 21 of the CLA reiterates this common law test. Case law also demonstrates the operation of this principle in practice. In Rogers and Whittaker, a surgeon was found in breach for failing to warn of a 1 in 14,000 risk of sympathetic ophthalmia, which was material given the plaintiff's near blindness in her other eye. In Chapel and Hart, even a low probability risk was found material because the patient would have chosen differently if she was warned. Rosenberg and Percival reinforced that breach must be judged at the time of advice, not with hindsight after harm occurs. Similarly, in Henderson and Lowe, liability was imposed for failing to disclose a small but foreseeable post-surgical risk that a reasonable patient would have considered significant. These authorities confirm that breach in failure to warn claims is patient-centered. The decisive question is whether the patient received enough information to make an informed choice, not whether the medical professional would routinely have given such a warning. Establishing that a duty of care has been breached is not enough to establish a causal link between the harm suffered and the failure to warn. Causation in failure to warn cases requires proof of both factual causation and the scope of liability. Section 11 of the CLA provides that the breach of duty must be a necessary condition to the occurrence of the harm, and that it must be appropriate for liability to extend to that harm. The but-for test asks, but for the doctor's failure to warn, would the injury have occurred? In failure to warn cases, this takes the form of a counterfactual inquiry. Would the patient have gone through with the treatment had they known the risks? Unless the plaintiff can prove that disclosure would have changed their decision, causation fails. The High Court in Rogers and Whittaker confirmed that the undisclosed risk must be essential in the decision-making, not merely relevant. In failure to warn cases, this requires evidence that the patient would have declined or delayed treatment had they known the risk, which can be challenging to prove and highly speculative. Per Section 12 of the CLA, the burden of proof falls to the plaintiff when proving causation. In failure to warn claims, studies suggest that causation is often the failing point for plaintiffs. Johnson's 2014 review of current failure to warn processes in Australia draws attention to the issue with placing the evidentiary burden on plaintiffs. This is required even if a breach by failure to warn of risk has been successfully established. Johnson's review also indicates that between 2003 and 2013, causation was the primary point of failure in all unsuccessful cases. A study by Bradfield and others found that of the 481 cases involving a failure to disclose material risks, most disputes arose on factual disagreements about what was said in consultations. This indicates the evidentiary barriers plaintiffs face in proving instances of non-disclosure. These findings are confirmed by Bradfield's 2022 empirical research on medical negligence, which demonstrates an obvious gap between patients' formal rights and their capacity to enforce them through legal processes. The IP report-based Civil Liability Acts implemented since Rogers and Whittaker have further entrenched these challenges by raising foreseeability and proof thresholds, further enforcing professional practice defences that make the evidentiary burden of plaintiffs proving what they would have done increasingly difficult. Even where a plaintiff successfully establishes duty, breach, and causation, medical practitioners may still avoid liability if a statutory or common law defence applies. In Queensland, the relevant defences are primarily contained in the CLA. Sections 13 and 15 of the CLA deal with obvious risks. A medical practitioner does not owe a proactive duty to warn of risks that would have been obvious to a reasonable person in the patient's position. Obvious risks include risks that are obvious or a matter of common knowledge. In failure to warn claims, this defence is unlikely to succeed where the material risk is rare, technical, or not readily apparent to an ordinary person. For example, in Rogers and Whittaker, the risk of sympathetic ophthalmia, though well known to specialists, was not obvious to the plaintiff, and therefore the duty to warn was not displaced. Section 14 provides that if a plaintiff is aware of the risk and voluntarily accepts it, the defendant is not liable. This is a codification of the common law valenti non fit injuria principle. In practice, this defence requires proof that the patient had an actual knowledge of the risk. In the failure to warn setting, voluntary assumption of risk will be rare, as these claims usually arise because the plaintiff contends that they were not warned of the risk at all. The most significant statutory defence in medical negligence is the professional practice defence under Section 22 of the CLA. However, subsection 5 of Section 22 states that the defence does not apply to liability arising in connection with the duty to warn of risk. As a result, Section 22 cannot be relied upon to justify non-disclosure. Nevertheless, its inclusion in the CLA reflects broader tort reform policies that sought to rebalance liability in favour of medical practitioners. While the CLA provides several defences in medical negligence, their impact is limited in failure to warn cases. The key reason is that most statutory defences preserve the patient-centred duty to disclose material risks. Defendants, therefore, rarely succeed on obvious risk, professional practice, or voluntary assumption of risk in this context. The more significant barriers to recovery remain in causation and evidentiary proof, rather than in the availability of defences. Critiques of current negligence law processes in Queensland, particularly in failure to warn cases, demonstrate the disproportionate barriers placed on plaintiffs. The requirement to establish factual causation under Sections 11 and 12 of the CLA is particularly onerous. Plaintiffs must prove, often hypothetically, that they would have acted differently if warned of the material risk. This can be complex to prove in practice. These barriers undermine both access to justice and the compensatory aims of tort law. An effective reform would be adopting a distributive justice approach through a no-fault medical compensation scheme, similar to New Zealand's Accident Compensation Corporation, the ACC. The causation test for the ACC requires that the assessor must be satisfied on the balance of probabilities that the injury was more likely than not caused by the medical treatment. This approach removes the evidentiary burden faced by plaintiffs in Queensland. Rather than requiring proof of breach and causation, a no-fault model provides compensation based on the fact of injury, eliminating the need for patients to satisfy the tests for causation. Distributive justice emphasises the fair allocation of risks and costs across society, recognising that medical injury and non-disclosure are societal risks, rather than solely individual wrongs. According to Knight 2022, New Zealand's ACC scheme resolves more claims more efficiently, with significantly lower transaction costs and broader coverage than false-based negligence systems. Separating accountability from compensation encourages improved reporting of medical errors and strengthens patient safety frameworks, without creating fear of disciplinary litigation for medical professionals. Regulatory mechanisms and professional disciplinary systems can still ensure that medical professionals disclose material risks. Although the personal injury compensation averages around $12,000 for New Zealand residents, compared to Queensland's average of $372,000, only 1,000 claims were accepted in Australia, significantly differentiating from New Zealand's 4,670 awarded claims. Some alternative reforms have been considered. For example, adjusting Queensland's medical liability negligence system to shift the evidentiary burden for causation to the defendant. Moreover, adopting hybrid models to combine fault and no-fault elements could also improve outcomes. However, such incremental changes still leave plaintiffs subject to adversarial litigation with its associated costs, delays, and uncertainties. In contrast, a comprehensive no-fault system, grounded in distributive justice, more effectively achieves fairness, efficiency, and predictability for injured people and society as a whole. Ultimately, the most effective reform in Queensland would be the adoption of a comprehensive no-fault medical compensation scheme, modelled after New Zealand's ACC. Queensland's current framework for failure to warn claims creates significant barriers for patients suffering personal injury as a result of non-disclosure. While the duty of medical practitioners to disclose material risks is well established, in practice, plaintiffs struggle to prove causation under Section 11 of the CLA. The requirement to demonstrate that they would have chosen differently had they known the risk protects doctors rather than protecting patients. Defences codified in the CLA demonstrate the rebalancing of liability in favour of medical practitioners. The current negligence framework does not adequately balance the interests of medical consumers, injured people, or society. Reform through the implementation of a no-fault system would provide greater fairness, efficiency, and predictability, realigning the law with its compensatory purpose through a no-fault system. This would allow help and resources to be provided in a timely and economically efficient way that protects patients and medical consumers, rather than sheltering doctors from liability.